All right. We are here tonight to talk about Oracle v. Google and kind of
Yep.
the tech and the law side of that. So I think we were going to have you start off with the tech side and then jump to the law side and kind of just.
So Oracle v. Google. This is a story that goes back. Oh gosh, I actually have to find out when Oracle bought Sun. This goes all the way back to before 2009. So this whole thing's been going for a long time. So back when Sun Microsystems existed, Sun Microsystems originally wrote Java. They worked with a whole bunch of different companies, including Oracle, Google, Apache, et cetera, on various Java technologies. One of the Java technologies that Sun was trying to make was called Java Micro Edition, where it's kind of a pared back, toned down version of Java that can go on mobile devices, such as those newfangled smartphones that people were starting to make. Um, except no one actually cared. Google started developing Android at about this same time. Well, actually, probably several years later, where Java ME wasn't really going anywhere. So Google started developing Android, and they decided that the main programming language they were going to use on it was going to be Java, because everybody knows Java. Usually it's a pretty good idea to go with the language everybody's heard of, everybody uses. So Java was a pretty natural thing, especially because Sun had been working really hard on making making Java be as kind of an open standard as much as possible. But the problem was, Sun was a little bit uncomfortable about the whole thing. They had put a lot of energy into developing Java ME, and that's not what Google did. They basically took the entire API that Sun had made, minus a whole bunch of other things, because you didn't need to have like the Java the Java GUI system in Android. You could make your own. But a lot of the other core components of Java they did include, and basically just took the API wholesale. Sun wasn't too comfortable with it, but they were trying to work with Google to try to come up with some kind of beneficial arrangement so that they both could, make something about this whole thing. And then in 2009, Oracle, trying to expand out their portfolio, particularly with regard to working with hardware. Sun Microsystems was originally a hardware company, much like IBM. They built servers, they built mainframes. Oracle bought out Sun Microsystems, including their rights to Java. And then they found out about this neat little tussle that Sun Microsystems was having with Google. And they figured that they could get a lawsuit out of it and maybe win a whole bunch of money from Google. And so that's the start of Oracle v. Google, which, as you know, was trying to assert copyright ownership over the Java API.
When you say that everybody already knew Java, one of the things that they focus on when we were talking about the decision itself is how much more difficult it would have been to use a different language.
Mm-hmm.
Like in your experience, how much more difficult would it have been? Like, what would that have represented to Google if they'd had to use a different language?
So at the time, there wasn't a lot of programming languages that were even out there. You were either .NET, Java, C, C++, or Python. It's pretty much all that anybody used. Apple was doing some stuff with Objective-C, but you only really dealt with Objective-C if you were actually dealing with Apple. So, in order to get the expertise from a lot of programmers, you want to have a lot of comfort with the programming language that's out there. So when you're dealing with a brand new platform that's trying to break in, trying to break through, it's not the powerhouse language, it's not the powerhouse platform that it is today. They were trying to get people to do something with it. Knowing Java means you know the syntax, you know the API, and you know the kind of the standards that people actually use, the programming standards, the style. So it's much easier for someone else than to pick up what you're doing and to run with it.
Okay.
So definitely the syntax, the way you actually write the programming language is going to be very comfortable to a programmer. Plus, if you are including all of the core Java classes that everybody knows about, um, system, string, integer, a bunch of the utility classes, array lists, maps, things like that, then it's going to be a lot easier for you to get in. You're not going to have this huge learning curve of learning something brand new while you're also learning a brand new platform.
And can you define what an API is specifically?
So let's actually start out a little bit what a language is. So a programming language has a bunch of very basic things it can do. You can create variables, you can create what are called conditional statements. If this thing is true, then do this code. Otherwise, do that code. You can do loops, iterating through a bunch of code over and over and over again, either based on another conditional. If this thing is true, run this line of code again. Or you can do what's called an iterative loop, where you have a variable, I, starts at 0, goes to 100. Basically, you're doing the same chunk of code 100 times. Well, this doesn't get you much. You really can't do too much except maybe add, subtract, multiply, divide. An API allows you to get access to a bunch of other resources that are available either in the virtual machine itself, such as system resources, things like that, more complex data structures. So rather than just integers or floating point numbers, you can also have lists, or you can have what are technically called bags, basically an unordered collection of things, whatever the things you might want it to be. Or you can have what's called a map, basically for any key, for any particular thing, there is a value associated with this. And a map is just a collection of all of those things. Each of these types of things have different advantages, different disadvantages, and are useful in different ways. Third, it can be different system resources, such as being able to put something out on the screen, being able to pop up a window, being able to get input from a user. All of these are part of an API, and it's what allows you to create a useful programming language. Back in the 50s and 60s, when they were first starting to develop programming languages, you literally had to understand those very fine details of how each platform worked in order for you to figure out how to put a letter on the screen, or how to read from that system's keyboard input, basically like only slightly better than are certain wires have high voltage or low voltage. Understanding what this particular key code is to be able to understand, oh, he wrote the letter K, I can do something now. Being able to do something that's a lot more useful and a lot more generic, that's what an API is. One of the first popular APIs was written for the C programming language, and they did something that people thought at the time was impossible. Literally being able to have a programming language with a standard API that can work on literally any platform where you implemented that API.
Okay. So functionally, Java was the most widely used and comfortable language for programmers, and then the API is what made it do the things that programmers wanted to do. Without it, it wouldn't have been useful functionally.
Exactly.
Okay. that forms a lot of the background. Baby Kosh feels like languages these days are less useful as a core than Basic/Pascal came standard.
What do you mean useful as a core? That's I'm not quite sure what you mean by that.
He said without the API. So he's saying without the API, they're less useful than like Basic or Pascal.
Significantly, yeah, less useful. But basically before C, you had stuff like Fortran, but Fortran was only really useful in the mathematical world. Even Basic had some ability to had almost like a very rudimentary API. Pretty much all it could let you do was print something to a string or accept an input, but it was still today that would be considered a form of API. You're almost having to deal with raw assembly, basically raw instructions to a CPU to tell it I need to read from a particular block of memory. I need to wait until I get an interrupt telling me that a key had been struck so that I can recognize the key, put it into a block of memory so that I can read it later once I get the second interrupt for the next key. Very raw, very rudimentary, and an API allows you to not care how that hard work is done. You don't need to care how a keyboard works. Or a little bit more realistically, you don't need to care how a printer works. You don't need to care how the printer understands the instructions in order to put something onto a page. Every printer is very different. But you don't need to care. All you need is an API that tells you to print this onto a piece of paper.
Ari said, well, Basic and Pascal had a certain standard library of functions built in. The C family of languages, C, C++, Java, Objective-C, C#, etc., generally come with standard libraries these days, but it's severed from the language itself. It's like having a grammar, but no nouns or verbs.
Exactly. That's exactly right, Ari. And it's this API that you're talking about with Java that was at question in Oracle v. Java, in Oracle v. Google.
And so one of the interesting things from the law perspective is that this dispute has gone up and down the courts multiple times. And that's not...
It's been going for a decade.
Yeah. That's not uncommon in these big kinds of litigation, where you will have some like early issues that go up to the Supreme Court, and then they go back, and then they proceed a while, and then there's a later issue, and then, you know, here it was a rulings from lower courts. What got to the court and was decided earlier this month was specifically a copyright dispute. And that's really interesting because reading the opinion, there's an underlying question of whether this kind of programming can even be copyrighted. And from reading the opinion, Justice Breyer really wants to get into that discussion, but it's also clear that none of the other justices want to go there right now, because he specifically says, we're not going to answer that, because if we answer the other question of whether or not the use of the API, and specifically a certain number of directly copied lines of code, count as fair use, we don't have to even answer that question. And that's in line with the Supreme Court doctrine of avoiding the big questions if you can get away with only answering the little questions. Yeah. The Supreme Court does not like to set big precedent if it can set little precedent instead.
Well, consider what it means to set big precedent.
Right. No, there are some canons of statutory interpretation or canons of judicial interpretation that I think need to be reconsidered. But the idea that you decide on the narrowest grounds possible is definitely not one that I think is wrong at its heart. So Ari asks, coming to your question about can the disputed lines of code even be copyrighted, what is it that the disputed lines of code are designed to do? I wonder if it's similar to another case about is it GNU? Is it pronounced GNU?
GNU.
GNU red line, or read line rather.
I'm not familiar with any controversies around GNU read line. That's interesting. Read line, I presume, is the C function that you're talking about. That I'm asking Ari indirectly.
Right.
So a lot of times, so basically an API is defined by two things in Java. It's defined by it's defined by three things. It's defined by the class declaration. So basically the name of the class and what interfaces does the class implement, and what class does this class extend from. And second, it relies on the method declaration. So the visibility of the method, is it a static method or a class method? Basically, is it who owns it? Is the method owned by the class, or is it owned by an instance of the class? The name of the method, the parameters, and any exceptions that might be thrown. And the third thing is the Java docs, the actual documentation that describes what the class and the methods actually do. There's also public fields, either static or regular fields, but those aren't as useful as a lot of. So there are public static final fields, which are like constants, and they are kind of useful. But really, the methods are what's the most useful, and it's these things, those method declarations and class declarations, that you don't have any choice but to copy nearly verbatim.
Yeah, and that's just as I was just pulling up the specific opinion, Justice Breyer specifically mentions the method calls as being kind of at the heart of this, and goes to point out that they are named very pragmatically. Like this is not, it does not represent a great literary or artistic work to put in these codes and to name the things that you have to name them to get them to work. And so he clearly, I think, wants to come down on the idea of no, you can't copyright them. But because of the way the Supreme Court works and the way Supreme Court kind of backroom politics work, if he wanted to get to the outcome that he thought the law demanded, he needed to have at least 4 other justices on board. So he leaves, I think, ample hints that he would be open to revisiting that, but they don't decide copyrightability generally today, which makes sense. Breyer is not a copyright maximalist by any means. I think Google probably knew it was going to have a good day when it was announced that Justice Breyer wrote the majority opinion.
Maybe. I think at the time they weren't quite sure.
Well, that's one of those things where, like, as soon as you hear, like, there are certain justices where when you hear that they've written on a certain topic, you're like, oh, this is going to go this way. As soon as I heard it was Breyer, it was like, oh, he's not going to have extended copyright. And it's one of the areas where, being someone who is more liberal, like, I'm kind of glad Ruth Bader Ginsburg wasn't on the court for this, because Ruth Bader Ginsburg was not good on copyright as far as I'm concerned. She was very much a copyright maximalist.
So that's actually interesting the way you say that, because my understanding of the ruling was that they accepted the lower court interpretation that API was copyrightable, but they were answering a question about fair use.
So they specifically, in the opinion, say Google appealed the copyrightability question. The majority opinion says, if we find fair use, we don't have to answer the copyrightability question.
Sure.
And since we find fair use, we're not going to answer it.
So I'll ask you this question, kind of knowing the answer, but that's a little bit what we're doing. What does it take to copyright something?
So copyright in the US after 1976, and then even more after 1989, requires only that a creative work be fixed in a tangible medium of expression.
Wow, that's a very interesting phrase. What does tangible mean?
Anything.
Okay.
Literally anything.
Okay.
Like, it's the US was a holdout in copyright law for a very long time. The rest of the world signed on to the Berne Convention for the Protection of Literary and Artistic Works in 1889. We signed on to it. Yeah, we signed on to it in 1989. So we held out for 100 years. And in that 100 years, we had weird definitions. Like, so that language that I just cited is specifically from the Berne Convention. We, for a very long time, said, no, it has to be published. And not only does it have to be published, it has to have a copyright statement. Not only does it have to be published and have a copyright statement, you have to register it by sending copies to the Copyright Office, to the Library of Congress.
Mm-hmm.
For a while, you had to send a copy to the Secretary of State, to the Library of Congress, and to the Smithsonian.
Why? Secretary of State mildly makes sense. Library of Congress definitely makes sense. Why Smithsonian?
I think for the preservation value. The idea was that nothing should be able to be copyrighted if you cannot go to a reasonably well-known source and find out if it was copyrighted.
Was the Library of Congress not this at that time?
I mean, so we're talking, like, when we're looking at these restrictions, we're talking about, I think, the Copyright Act of like 1835, and then the Copyright Act of 1909. So, like, these are by 1976, registration is just send it to the Library of Congress. We don't need the Secretary of State. Doesn't make sense if it's the National Secretary of State, because they don't deal with that kind of thing like a state Secretary of State does.
Right.
And the Smithsonian just got whole out of the business.
I almost wonder if that was mostly actually, rather than like that's where you preserve it, if it was more of to give the Smithsonian some legitimacy, because at the time it didn't have much.
I mean, entirely possible. So we also, during most of that time, our copyright term was severely limited. Like, I think the act of in the 30s changed it from a 14-year term with a 14-year renewal to a 14-year term with a 28-year renewal. And then the 1909 changed it to a 28-year term with a 28-year renewal. Meanwhile, the Berne Convention was life of the author plus 50 years.
Mm.
So we had a much more limited definition of it, going back almost to what was in the original copyright law, the first copyright law, which was the Statute of Anne. And then the definition as it was passed by the first Congress, which was 14 plus 14. And that, specifically U.S. copyright law, is interesting in that we are very specific in what we allow to be copyrighted, because you cannot copyright something that is essentially a pure recitation of fact. That's why phone books have all that other crap in them. It is the order in which you place the facts. It is the stuff you put around the facts that's copyrighted. Same with recipes. The reason why everyone tells you about their grandmother in the south of France that taught them how to bake bread in those warm nights in Marseille is because that's all that's copyrighted, because you can't just copyright bread.
Oh, okay.
Yeah, that's why recipes online are so annoying. And so the question is, given
I read so many
you,
articles about complaining about that, and so now that's the answer.
And that's why. Given how you described it and how Justice Breyer describes it in the opinion as being almost mechanistic, right? Like there's nothing else you call it. This thing does this. It's called this. You write a thing that says, go get this and do it. That's what the argument comes down to as to why, to some, that shouldn't be copyrightable, because we don't copyright what the term of art is useful articles. If something's primarily useful as opposed to primarily being creative or literary or expressive, we don't copyright it, which is why for a long time there wasn't any ability to copyright fashion, because clothes, the design of clothes, are useful articles, right? There's only so many ways that this shirt can cover my horrible body. That changed in 2016 in a case that I was actually filed an amicus brief in, where they talked about the copyrightability of cheerleading uniforms, and they had oral arguments on Halloween because someone has a sense of humor. And there they allowed it to be that you can have a copyright in the underlying design drawing of fashion, even if you don't have it in the actual piece of clothing itself. And so that may become relevant now that we are moving into maybe a time when we're pushing back against copyright maximalism, and maybe programming, especially the kind of mechanistic programming at question here, isn't copyrightable. Is there some design plan that you can claim to have a copyright in, even if the code itself can't be copyrighted? But I don't think any of the justices, maybe besides Breyer, really wanted to get into that, so they didn't. And
well,
so
probably very few of them even understood what code was.
Well, and that's at the risk of going down another rabbit hole. That's part of what makes the majority opinions so fascinating. You rarely get Supreme Court majority opinions with technical appendices, and it's great to see an attempt to, let me pull up the pages for it here. Breyer dedicates a lot of time to explaining the API, because its function, especially that mechanistic aspect, is at the heart of his decision. And I'm going to hold it up to the camera, which is a terrible way to do this, but go look up the Google, if you look up the opinion.
Why don't you send me a link to that, and I can share my desktop as well.
Let me do that real quickly. I will send it on Facebook so that I don't screw up our Discord call. And that is an ongoing problem, is that both politicians and judges tend to be a little bit older, especially by the time you get up to circuit court and Supreme Court. Even the young bucks like Kavanaugh. I think Kavanaugh's, a hard-charging young man in his 50s. Justice Roberts, who has a reputation of being so, such an energetic chief, is retirement age. And so you have people who are a little bit older having to decide and make the laws on these issues. But I think Breyer, who is ironically one of the oldest on the court, does a really good job of laying out the groundwork for this, because it is so important to what he thinks the law supports. Because what he does come to is that it is fair use, right? So fair use is a defense to copyright infringement, which means the copyright things that people put before YouTube videos are completely meaningless. Not having that will not make it not fair use. Having it will not make it fair use. But
you're just proclaiming, like pre-proclaiming, I declare this to be fair use.
You are saying
there's an awesome video from Tom Scott where he kind of talks about that kind of thing. And he kind of mocks people that do exactly what you just described, that somehow saying fair use is not going to keep a lawyer from coming at you. And then he gets the guy from Legal Eagle to pretend to be Dracula and say, I want to sue you now. And someone with a little cross said, no copyright infringement intended.
That's all right. Dracula's in the public domain. Video. Yeah, and it's all you are declaring is, in my opinion, this is fair use. And it's like, well, great. The court will take your opinion for exactly as much as it's worth. And one of the things that he goes through in the fair use analysis is how necessary it is. And he even, to the point where it is, if it's not overruling some previous decisions, it is definitely skirting the line, because he even talks about how little code they directly copied compared to the whole code that they didn't copy, that they programmed themselves, and compared to the whole amount of Java's code. And that's interesting, because it really gets... There are previous cases saying the infringer cannot excuse his infringement by showing how much he did not infringe.
Yeah.
And while there is a standard that's considered in the 4 fair use factors of how much of the work you took, the reverse is not necessarily you cannot show how much you didn't take, show that what you took was important.
Right.
And so he goes through, and he also spends a lot of time talking about what is kind of I think Mike Dunford on Twitter called it the utilitarian argument for copyright. That they are using the API and the stuff that they admit they just whole ass copied to then go and do so much more, because now you have Android, and it is a hugely popular program. It's a hugely popular platform,
and it's a fundamentally different platform.
Yeah, it is spurring on further innovations, and he puts a lot of stock in the idea that it is more okay to do this because Google is using it to spur both its innovation and other innovation than it would be if it was a much more closed system, or solely something they just made and profited off of without it also having this spur to innovation.
Right.
He also talks about necessity, and to the point where my brother and I are actually writing a law journal article about how it is kind of a radical change in how you view fair use, to frame it around, are you using what is necessary to make your creative work? And if you're using only what is necessary, great. And if you're using more than is necessary, then that's probably not fair use. And so because they use this tight little bundle of very utilitarian code, and they left so much code undone, and they are fundamentally making a very different thing than anything that Java had done before, or Java was used for before. It is transformative. It is not cutting into their market because they're not in that market, and the idea that they can potentially someday be in that market doesn't mean it's not fair use. And they only took what is needed, and so it's fair use. And he got multiple other justices to sign off on that. I think it was like 5-3.
I think I heard that it was 5-3. Yeah.
Breyer, Roberts, Sotomayor, Kagan, Gorsuch, and Kavanaugh. No, it was 6-2, because Amy Coney Barrett was not on the court when they argued it. So she,
that's right.
If you're not on the court, if you're not on the court when it's argued and there's not a re-argument, then you
They
don't take any
usually,
part in the voting.
So was there one dissent or was there two dissents?
So there are two dissenters.
I know, but there's a difference.
Thomas filed an opinion, filed a dissent in which Alito joined.
Okay.
It's actually a pretty clean decision as far as the Supreme Court goes. There's an opinion, there's a dissent. I mean, that's...
It's rare when there's not.
Yeah, they get a lot uglier than that, for sure.
So, I guess I'll get into why this was so important from a computer science standpoint, not just from a law standpoint. Basically, ever since C came out, which is, I think that came out probably in the 50s or 60s. It's an old language. The idea of having an API that a language relies on in order for the language to actually be useful is how you write programming languages these days. You don't write every aspect of the programming language to do everything you want. You rely on pre-made APIs to help you. And even more so, you rely on other people creating additional APIs, something completely separate from that core API, that core Java that was that question in Oracle v Google. Additional libraries that other people can create for themselves. There are several times though where a library that someone makes is no longer being supported. And so now you have to take it and you have to expand upon it in order to make it work the way you want it to. Now, for a lot of those kinds of APIs that are out there, the new ones that are coming out, a lot of them are released in using different copyright licenses. The GPL or the MIT licenses or BSD license are a couple of the more popular ones, and there are many others. But sometimes they're not. Sometimes the code is released, but there's no explicit license out there. And so basically you're relying on raw copyright law. The person could put his code out there, wanting everyone to use it, but then later on, it becomes extremely popular, but the original author, maybe now dead, is no longer maintaining the code. Someone else takes it and maintains it and expands upon it. And maybe knowing potentially the copyright issues, instead of just taking that code wholesale, re-implements it. Maybe they needed to re-implement it for a different programming language. What was once in Java needs to now be in Kotlin. But the names of all the classes, the names of the variables, the names of the packages even, they all have to be the same in order for things to work right. And so now you could have very easily created this problem of, well, now the estate of this person can sue and destroy all this work that's been done, destroy all the people who have been relying on these libraries, because you're now infringing on a copyright that is only due to a single line of code in some of these cases, because you gave it the same name, you gave it the same parameters, but that counts as being part of copyright, because what is a derivative work? What is fair use? All these different questions that come into play. I could easily imagine it's probably not going to work out that way. I'm not sure how modern copyright law can be retroactively applied, but the original authors of C, there was no such thing as a copyright license back then, where you could free your code up to be used by anyone as long as they abide by the terms of this license. C was written too early. could one of the original authors of the C standard library or one of his descendants claim copyright ownership and now destroy one of the most important programming languages that exist? Pretty much every operating system is written in C. Every operating system uses and re-implements the C standard library. What happens when that's now claimed under copyright?
Yeah, and this is such an important decision because it takes an impulse that had already existed. Like there's a case from the Second Circuit called Carrier v. Prince that basically says, oh, hey, the only thing that matters is transformative use. Everything else is subordinate to transformative use. And there'd been a strong push of transformation as being important for a long time leading up to that. And that's unsettled. Overall, there's a circuit split on it. But I think Breyer took that case or that impulse and said, yeah, transformation is important, and we should be rewarding transformation for innovation. We should be rewarding transformation for the creation of new things which contribute to the public good. And so I think we're going to see, as those cases start to come up, I do think we are going to see the idea that something like, if you re-implement it, then that is a transformative work, and you are transforming it sufficiently for fair use, even if you're commercializing it, because obviously the Android platform is heavily commercialized, right? It's not like Google's not trying to make money, but that's okay because it is still fair use, because it's transformative and because it is using what's required. And I think the next decade of litigation in this area is going to be people trying to say why Google v. Oracle doesn't apply to them, right? Why it doesn't apply to their field. Immediately after it came out, you got a number of articles like, Hollywood isn't worried about Google v. Oracle, and here's why. And it's like, oh, they're not worried because they're trying to get out ahead of it and say, well, but this is only for software. It doesn't apply to movies. I'm not sure. I think that this represents a sea change in fair use, and it's going to be fascinating to see what happens with it. Baby Caution and Ari both say C is from 1972.
Okay.
And Bobamk specifically asks if the Bela Lugosi interpretation is in the public domain. Probably not.
And Janissary asks, are copyright disputes in programming languages, do they happen often? I haven't heard of many. Yeah, in my experience, I haven't seen anything of that kind of sort, honestly. Have you ever heard of anything?
Not as much, and for a couple reasons. I think because so much of software programming does rely on other people's work that you may not have the rights to, I think that one, there is a much more collaborative culture, except when it's, billion-dollar companies. And two, a lot of people don't want to upset the boat to the point where the Supreme Court actually has to rule on whether or not it's copyrightable at all.
Mm-hmm. And actually, as I said that, I'm reminded of a case that actually does revolve around. It's not about programming languages as such, but it is about implementations of API, and that's SCO v. IBM. Are you familiar with that one?
I don't think I am off the top of my head.
So this is a long-running dispute between I forget the official name of the company. A company that's called SCO, SCO. I think it was originally Santa Cruz operation, but they changed names a couple billion times. Against IBM for having taken SCO's copyrighted code and inserted it into Linux. And that was a particularly interesting interesting argument, because basically, from a non-legal standpoint, it really looked like it was SCO trying to take financial opportunity of IBM and everyone who uses Linux, because shortly after they sued IBM, and I don't even think there's actually an official opinion about it yet, well before they ever got any judgments, they were trying to strong arm several major users of Linux to basically take money from them because they're using their copyrighted code.
Well, and so some of them, looking it up quickly, some of them come down not as much to pure copyright infringement as in you copied, but also there's licensing agreements which they claimed are violated, and that's where I think you see most of the litigation in this kind of area is not
You really do.
pure copyright, but you violated the terms of our license.
They did try to claim that GPL was unconstitutional.
Wow. Okay.
Basically, it denied Congress the right to regulate copyright.
That's no. No. No.
I mean, to tell you honestly, the point of GPL is to use copyright to your advantage and to say, I'm going to open my code up to everybody to use and prohibit anybody from using my code in a closed environment.
Yeah. No, it's the fact that you can voluntarily decide to put something in the public domain means you can voluntarily decide to kind of put it in the public domain.
Mm-hmm.
And it is, yeah, as Bobamk in my chat says, it is a bold legal position to claim that your ability to broadly license your work violates the copyright clause. That's
yeah. Yeah. I'm not sure what exactly that meant in terms of SCO's legal strategy, but there was a website named groklaw.net that was following this case very, very closely, but unfortunately, the person who was running it, I believe she was a paralegal, felt compelled to stop contributing to the site because she was concerned of all of her, basically because there was no guarantee that emails could be protected. That she could no longer, in good faith or trust in herself or the world, continue that site because she relied on email. I think she was going a little bit overboard, but considering the area of the the area of thought that she was in, she had to take it as she needed to. This was back when the whole questions about the NSA and their efforts in spying on everyone was very, very in the mainstream consciousness. And certainly she was out there. She was making herself into a target, unfortunately. Even though it wasn't necessarily a target of government intervention, it was certainly a target of political and commercial intervention.
Yeah. No, it is tough to. Yeah, that sucks. That I'm sorry that site got shut down because I was going to go look it up immediately.
It's not shut down. It's still up, but she's not actively maintaining it.
Gotcha. Well, still, I might go back and read that. Yeah,
you should. It has it's probably one of the. It's probably one of the better compendium, lay compendiums of legal documents that you could find. Because it's basically everything about probably 6 or 7 different related lawsuits that were all going on about the same time.
Bobamk in my chat is asking for a link to the chat. Is it just GROKLAW?
Let me double check.
And that's, yeah, it's most of the time you see these as
Yes, it is.
primarily, okay, and I will throw that out. You see these as being primarily license disputes. Sometimes, depending on what specifically is there, you might see trademark disputes. Oh, I'm sorry. Hold on. Before I sent it out as .com, not .net. There, that is correct.
Yep, that's important.
And it's yeah, so it is definitely, I think, different to see it as just a pure copyright dispute, but it is interesting, and I think that after this we will probably see, like I said, a lot of litigation trying to figure out exactly what the impact of this case is, because it is such a sweeping change in fair use as it applies potentially to everything, but almost certainly to software.
Certainly to software. By my understanding, and I have a limited understanding, I'm not a lawyer, but by my understanding, it pretty much makes the case law that even though API is probably copyrightable, just because of the way that copyright law is written right now, that API is basically open to fair use. Which actually leads to a next question for me, which is, I know a little bit about Justice Thomas's dissent, where he was basically complaining about that exact situation. So what was that all about?
So, with the caveat that Justice Thomas frequently, as I'm going to his dissent, Justice Thomas is frequently in his own kind of world.
I get that, but he did raise a very interesting logical statement, at least in my opinion logical, and that is, if something is by its nature fair, like protected under fair use, could the thing itself ever be copyrightable?
Well, so he says, because in the introduction, he says outright, properly considering that statutory text, Oracle's code at issue here is copyrightable, and Google's use of that copyrighted code was anything but fair. So he is specifically saying the court should have said it was copyrightable. And not only that, but it is covered by copyright, and that it was not fair use.
Mm-hmm.
And he goes through, and he's right that it 17 USC 109, 117, and 506 defines a computer program and recognize it as being copyrightable. Now, I would say that there is a difference necessarily, and you can correct me if I'm wrong here, between a program and pieces of code in a program.
There are, but there's actually a very interesting line between a program and an API in such that there really isn't one. The only real difference between a program and an API is a program is something that can be executed.
Okay.
That's its only difference. And unless you understood, like, basically in Java, what makes a collection of code executable is that somewhere in your code there is at least one class with a method declaration of public static void main with a single argument of type array of strings. If you have that, you have executable code. You have a program.
Okay.
But without that, what do you have? And me as a programmer, I don't see a clear-cut distinction between API and program. Now, I would definitely say a program should be copyrighted. and should be protected by copyright because this is a collection of code that's designed to work together in an integrated way to provide for a user experience or for some kind of communication from one program to another. To be able to store data, retrieve that data, and present that data. And several other, I could probably name a couple other dozen ways that you could do. Basically, user interaction, a user does a thing and the program responds in some way. But
So
an API is very similar to that.
interesting. And so looking at it, Justice Thomas is specifically saying that the majority is kind of doing it wrong, and that let me pull up his specific wording. The majority holds otherwise, concluding that every factor favors Google by relying in large part on a distinction it draws between declaring and implementing code, a distinction that the statute rejects.
Mm-hmm.
Tellingly, the majority evaluates the factors neither in sequential order nor in order of importance. At least two factors are more important under our precedent. Instead, it starts with the second factor, the nature of the copyrighted work. It proceeds in this manner in order to create a distinction between declaring and implementing code that renders the former less worthy of protection than the latter.
Mm-hmm.
Because the majority's mistaken analysis rests so heavily on this factor, I begin with it as well.
Yeah. That
So
to me is interesting. It is.
Yeah.
Because
And it's
declaring and implementing code, you could actually make a very clear distinction of that within computer science. There's a concept in Java and in several other programming languages called an interface. Literally, well, for the most part, what all you have are method declarations. You are declaring that there's a method of this type. It returns this kind of data. It accepts this kind of data, and it may throw this kind of exception. You need to have a class that implements it. Basically, between the curly braces is the implementing code. Outside of the curly braces is the declaring code. And I'm not sure what the statute actually says, but I suspect that the statute either does not or either does not make a distinction between the two, or suggests that there should not be a distinction between the two.
So he quotes that, according to Thomas, Google's argument also cannot account for Congress's decision to define protected computer code as, quote, a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Hence, Congress rejected any categorical distinction between declaring and implementing code. Declaring code does so indirectly by incorporating implementing code. When faced with general language barring protection for, quote, methods of operation, and specific language for protecting declaring code, the specific governs the general. And then he quotes a case that
that's an interesting phrase he uses, that implementing code incorporates declaring code.
That is what Justice Thomas wrote. Yeah,
that's an interesting way of putting it. I dispute that on a computer science level.
Okay.
Declaring code is nothing without implementing code. Implementing code doesn't incorporate it. Implementing code is held within it.
Okay.
That's very interesting. I have a question from Janissary. Is there overlap between how programs are litigated and how art copyright is litigated, such as with music?
I would say it depends on what he means by overlap. If he means, are they litigated broadly using the same statutes and over the same terms, they certainly can be. There is not much at heart different in the dispute over the API that Google copied than the dispute between Robin Thicke and Marvin Gaye over the beat of Blurred Lines. And I can't remember the original Marvin Gaye song, where the estate of Marvin Gaye said, you copied this underlying pattern of musical notes, and Robin Thicke et al. Said, we use similar notes, but it's not the same, and it's a different song, and blah, blah, blah. And there they lost. And so they are litigated on similar terms when they're pure copyright disputes, because to a certain degree, copyright is copyright. And that's one of the benefits of our copyright law, and also one of the downsides of our copyright law, is that fundamentally we use copyright to protect everything from music to novels to computer code. And so there are certainly overlaps. To an extent, copying is copying, but then there are definitely areas where you start to get into some nitty-gritty, and it's like, well, are these the same things? And you're trying to draw parallels in interesting ways, like the one I just came up with to Blurred Lines. So broadly, yes, which is why I think both sides here had computer experts, both law firms, because I think both sides probably hired boutique law firms for the litigation.
You kind of have to. Not a lot of not a lot of lawyers understand programming. I mean, in terms of law, in terms of the world, I mean, computer science has only existed for about, basically since the 50s. That's the start of computer science. So computer science has only been around for 70 years. How long has common law been around?
I mean, the Normans, actually the Anglo-Saxons. But what's interesting is I don't think they actually probably hired a firm that specializes in technology litigation. I think they hired a firm that specializes in Supreme Court litigation. And
you have to, almost.
And because that's the thing. And then they had people from Google and they had people from Oracle on each side going in and explaining, like, okay, this is what all this means. This is what all this is. But the number of people that do Supreme Court litigation, it is low enough, and you can tell when you're listening to oral arguments, and it's like, one side is people that do 3 or 4 Supreme Court arguments a year for the last 20 years, and one side is the Solicitor General of Arkansas, and it's like, one of these is way more prepared, and states should never send their Solicitor General to argue before the Supreme Court.
And yet that's what their job is, fascinatingly enough.
Solicitor Generals of states, I think, absolutely state Supreme Courts. The federal Supreme Court, you're a state. You can hire a boutique SCOTUS law firm.
You should. I mean, there's a reason why the Supreme Court finally said that to argue before the Supreme Court, you have to be on the bar. Because technically, for many, many years, for over 100 years, anyone could argue before the Supreme Court.
I did not. When did they say that? I did not realize that.
I remember reading an article where the Supreme Court made the decision that only registered lawyers can do that. And it was like many, many, many decades after the last person who was not a professional lawyer and on the bar of the Supreme Court argued a case before the Supreme Court.
Interesting. Now, what's
I think maybe only like 5 people ever did that at most. It might have only been like 1 or 2.
Which is interesting because you still technically don't need to be a lawyer to be appointed to the Supreme Court.
You don't, but who's going to appoint anyone to the Supreme Court who's not a lawyer?
And what the other thing interesting about that is, like, I could be admitted to the Supreme Court bar, and I will be as soon as I can arrange a trip to Washington, D.C. to do it. All it takes is 3 years of practice and somebody who is willing to sign off on you.
I mean, sometimes that's the toughest bit.
True. That's why if you look up the amicus brief that we filed in the cheerleading uniform case, there's another, the names on it are my name, my brother's name, and this random other attorney. And it's this random other attorney because neither Andrew nor I are admitted to the Supreme Court. So we needed a Supreme Court attorney to submit under. So yeah, so it's really interesting, and there's going to be a lot of changes that come from this. And I think people, like I said, people that are saying, "Oh, well, this doesn't apply to us," are doing so hopefully, because I don't know why it wouldn't.
So one of the best as I understand, one of the hallmarks of copyright is that it is supposed to protect creative work. Correct?
Yes. Generally speaking, if the early cases, especially, distinguished that it's not the only thing that makes it work is not the sweat of the author's brow, but there's a reason why it's the Berne Convention for the Protection of Literary and Artistic Works. There has to be some expenditure of creativity.
Right. And that's what's interesting to me, actually. We obviously, I shouldn't say obviously, probably in law the term creative is vague, intentionally vague, so that you don't try to create a hard line, and then what is obviously creative is not actually creative under law because you had a hard line. But what's interesting is I've been a programmer for more than 15 years. And it's only been within the past year that I've even started to accept the idea that what I do is creative. So for so many years, I would be considering the situation of I'm given a problem to solve with programming, and obviously anyone would solve it in the same way I do. And it took me so long just to realize, like, my current manager that I think I've only had for a year, maybe 2, he started talking about how programmers are creative people. And because we're creative, we need creative outlets. And I'm like, I'm a creative person? Really? Why am I creative? How am I creative? Because I'm like, if you were to ask me to draw something, I'm like, stick figure holding a pen, like, I draw stick figure holding the pen like this. I can't do that. But the idea of, I have the opportunity to write any program that I want, and this is how I write it. And that's a creative endeavor. That was so weird to me.
I think it's for a long time we've classified programming as purely that mechanistic side, and I think that it's I'm not necessarily willing to say that no programming can be creative, because it absolutely can be. And living with Mikey, who is very much at heart a programmer, and with his son, who is a budding programmer, and just seeing kind of that process that, Baby Kosh brings up an interesting point. We associate creativity with art, and creativity and art are not the same thing.
You're right.
And they don't have to look the same way, and we do a disservice to things when we do that. There are a lot of people who would look at a lot of areas of law and say it's not creative.
Mm-hmm.
And yet you know, the when I was in law school, I was on trial team, and they said, "Oh, we need, you know, you are our closer. You are the one who does our closing argument," because I'm good at them. And that ability to synthesize the facts of the case and the information that we've gotten admitted and presented in an accessible manner to the judges or to the jury is a very creative art. And as I've looked at more appellate work, there is definitely a creative aspect to the way in which you present your case in an appeal and the way you craft the brief. And I think there is creativity all over the place, and we need to be more recognizing of it. And not all of that creativity ends up with things that are copyrightable.
Sure.
But there is I mean, there's plenty of creativity in the world in almost every field. And I think we need to disassociate the idea that creativity is artistic creativity. Ari points out the act of coming up with something interesting, even just to yourself, is creativity. Finding a solution to an interesting problem can be creative, or finding an interesting solution to a not interesting problem can be creative.
Right. And I have to I struggle with that. I really do. I mean, it's kind of weird. Janissary is saying, like architecture, it's like architecture. It can be both functional, as in meeting specific requirements, and artistic. And that's true. But I don't know. I guess it's maybe a little bit of diminishing what I do as, you know, not being as creative as it is. And I guess I still struggle with that, because I just think of, I have a problem, I need to solve it. But, you know, just in the past couple days, one of my colleagues rather, was wondering how I was going to solve a particular problem. And the solution I came up with was what I thought very obvious. And I actually kind of held off on committing the code because I didn't want him to feel bad. Because he's a really good programmer. He's really good at what he does. I don't want him to feel bad. It's like, oh yeah, all you have to do is just do this. It's like 10 lines of code and then I'm done. I didn't want him to think like I'm diminishing or reducing his talents or anything. But then when I showed him and when I kind of explained it, it's just because he went about it in a different way than I went about it.
Well, and I think that there's two things at play there. One of which is we have tended to bifurcate STEM careers away from any idea of creativity. And we see exactly this in things like, we're surprised when an engineer is also a painter. Yeah. Or we're surprised when someone like Richard Feynman is a painter and plays the bongos. He was a bongo player. Some of my favorite books are his 2 volumes of his autobiography.
And he was a linguist.
He was everything. He was truly a true Renaissance man. And we're surprised when engineers and scientists are that way, in a way that we're not surprised when an artist is that way. And so we create expectations of how engineers and scientists are. And we force people that are inclined toward those careers to view themselves in those molds, and therefore what they're doing also can't be creative, because if you're creative, you don't go into STEM, and therefore what you're doing in STEM can't be creative. Mm-hmm. And I think you're also demonstrating you are educated in computer science and in programming, and so to you that problem was a simple matter of regurgitating a solution, whereas to me that would be insurmountable, because I would have to go get that whole education leading up to that in order to be able to immediately think of, oh, this is the solution. It's Miyamoto Musashi, writing in the 1600s about Japanese swordsmanship, described it as the no mind. The goal of swordsmanship and the goal of training is to get to the point where you do not have to think about how you are responding to an attack. Your body simply knows how to respond to it. And education in our fields is the same way. You have put in the hours to get to the point where it is obvious to you what to do in that situation. And so it seems obvious to you because you're not looking back at all of the work you put in to get to that point.
That is a very interesting way of putting that. And my initial reaction is to refute it because what I do is intrinsically intellectual. But I don't think that's what you're saying.
To Musashi, perfection in one thing was perfection in all things. He was the exemplar of, if you want to understand swordsmanship, pick up calligraphy. If you want to understand swordsmanship, read philosophy. You make yourself more perfect, and therefore you are more perfect in everything you do. I think that it's the intellectual, the fact that to you it was obvious is showing the fact that you built up that library of knowledge in your mind, and that you have those resources to draw on from all of the time that you put into doing it. And Ari is pointing out genius is not cross-domain, and I don't necessarily agree with the completely with the no mind philosophy, or the idea that becoming a master calligrapher helps you be a master swordsman. But the idea that training in multiple disciplines creates pathways in your brain, and that an extensive knowledge background creates instantaneous connections for you that would take more time and effort for other people, I think is absolutely true.
Yeah. I actually agree with something Janissary said. She said, she mentioned the left brain versus right brain myth. And she's absolutely right. That's very much a myth. There are no left brain versus right brain people, but so many of us think in those ways, that there's the creative and then there's the rational. For so long, I think I did that right. I think left is supposed to be logical. I don't remember. But for me, programming is a very logical thing. You're trying to figure out, you have a problem, you break it down into a bunch of different, not different, a bunch of smaller problems. You solve each of the smaller problems, you coalesce them back together, and now you've solved the larger problem. And the only skill you need is the ability to break the problem down into smaller bits and put the bits back together after you've solved them all. But that, I guess, for me, I'm trying to process through the idea that the breaking apart of a problem, the designing of a solution for each individual problem, and the recoalescing of that problem is itself a creative endeavor, even though that is an engineering thing. That's what engineers do. That's what logical people do. It's the idea of, how do you eat an elephant? One piece at a time. It's physicists assume that all cows are spherical kind of crap. It's weird to think of that kind of endeavor as being creative, but when you think about it, it is. And I don't know how to process that yet.
I could show an automotive engineer, an automotive technician, who was very good at their job, all of the pieces of an engine,
mm-hmm.
and they could put it back together. They could also probably take a collection of pieces and make an engine. It might not be, an engine that would run in my car, but they understand the interactions between the parts enough that they could make a functioning engine or motor. Not that I know the difference. Whereas I could just look at a pile of parts and tape it together and nothing would happen.
Right. If you did the same thing, there'd be a pile of extra parts and the thing doesn't work.
Right, and I'd have no car. And
but if the automotive engineer did the same thing, there'd be a pile of parts and you have a beautifully running engine.
Right, even if it's not an engine in the exact same shape that my car's engine is, they could make it out of the parts. And I think that is the creative aspect. You have the ability to break the problem down into those component pieces, and then equally importantly, put it back together. And maybe you are not putting it together in the way that you originally thought you were going to, but by solving those individual problems, you find a way that works better, or a way that is more efficient, or a way that is more aesthetically pleasing. And so you put it back together in that different way. And that is showing the exercise of creativity, because you could have put it together a different way. It may be obvious to you that that's the right way, because it does more of what you want it to be. Mm-hmm. It does more of what you want it to be while looking like you want it to look. But that is getting it to that part is the exercise of creativity, and is only obvious to you because you're not outside of your own head. One of my favorite authors is an author named Lois McMaster Bujold, who wrote a series called the Vorkosigan Saga. And one of the repeated lines in the Vorkosigan Saga is, "The fish does not recognize the water it swims in." And
whoa,
yeah,
that's cool.
Yeah, and it's so useful to be like, okay, let me look at myself and try to take an outside view of me. What are the things that I'm doing that I don't think about? Because the fish just swims while we marvel at the gills. Mikey says there are 2 wolves inside of you. One of them is trying to put an engine back together. It's a very smart wolf. You should send that wolf to college. And Ari says, yes, but a real engineer will sell the parts and buy a moped, much more fuel efficient.
Well, it might be more fuel efficient, but it is not better on the environment.
And then maybe quoted, if we taught a lion to speak, we would not be able to understand it.
That's true.
And I think it's...
that's actually an interesting idea, because we've taught a gorilla to speak. And yet it was imminently understandable.
Although there are questions of how much we actually taught the gorilla to speak versus we taught her word associations, but not grammar.
I don't know, because Mr. Rogers visited Coco the gorilla. And one of the first things that Coco did was take his shoes off.
Interesting. There's all I obviously
gorillas are very smart. Gorillas are very smart. So even if they are only understanding word association, we only understand word association.
All I know is that there have been some reproducibility issues with Coco. Baby Kosh, if a point is being made between 2 beings, communication is had. Sounding like adult Kosh very much in that.
Janissary, my parrot speaks, and it still just talks absolute nonsense most of the time. It's very true, but there are certainly smarter animals out there. Like Alex the African Grey. There are certainly there are a lot of birds that are extremely intelligent. Who asked the first ever existential question when learning colors. He asked, what color Alex?
Interesting.
That's
There's
very interesting.
there's vi-
Wow.
vid- there's video online you can find, and I'm trying to remember the name of a dog that is in an experiment where the dog has been given um like the Staples easy buttons,
Yeah.
but with different words. Bunny is the name of the dog,
Okay.
and um trying to see, can dogs acquire language? And it's had some really interesting results where Bunny has done things like demonstrate an awareness of time and demonstrate, like, we walk yesterday, and has recognized herself in the mirror. um and because at one point she was asked, who is that in the mirror, and she hit Bunny and friend. And at one point she asked, what is dog? And when was explained what that meant, responded with, dog is friend.
Oh.
Yeah, it's really sweet, but it's also really interesting and, like, I don't know, kind of concerning, because if dogs have that level of sentience, like if this is a reproducible study, we have to rethink kind of how we treat dogs. Like, if a dog has the sentience and sapience of a human child, like, you can't just sterilize your child or breed it and sell its children.
Well, yeah. There was one point in time when we thought we could.
Well, you're right. Modernly, we're not we're not so fond of the concept.
No,
Um,
not quite. Um,
but yeah, it's really fascinating stuff. And Noodly Wisdom, who just piped up in my chat that analogy got away from me, um, has watched a lot of it, and it's really interesting to see, like, oh, our animals, our dogs, might be a lot more aware of the world around them than we were willing to give them credit for.
I am of the opinion that consciousness is an emergent an emergent quality of a complex system.
Okay.
And we're talking about reproducibility of things like Coco or Alex the Gray Parrot. Or I'm sorry, Alex the African Gray. Um, I think that when it comes to some animals, like a lot of cetaceans, corvids, things like that, um, they are incredibly intelligent and may perhaps even be sentient. But the idea of sentience is so fuzzy that I don't know. Until we can identify it in ourselves, I don't know if we can ever identify it in others. And I don't know how capable we will ever be in identifying sentience in ourselves. Um, but I think I'm going to try to wrestle back the topic back
Yeah.
to
We got a,
copyright. We
although
did,
a
but
very interesting
only
digression.
vaguely, because we went into creativity for a while, and that's still part of it. So you were talking about copyright in terms of creativity and and various other things, and how there's a single set of laws by which we regulate copyright. And so I think I want to touch on the topic of the DMCA.
Okay.
Because for me, the DMCA, in a lot of ways, because of its prohibitions um, against trying to uh, reverse engineer systems that help protect copyrighted works, that it itself basically criminalizes creativity, in that it not creativity, criminalizes curiosity. A lot of times, especially in the engineering or in the programming world, the way that you try to understand something is by taking it apart, by breaking it, putting it back together and seeing if it works. Or with software, trying to re-implement it on your own or trying to break it and seeing how it works so that you can understand the whole system better. So I know that DMCA is used a lot, particularly on the platform we're on now, Twitch. I am planning on uploading this video to YouTube, but this is it's still relevant to online platforms of this kind of variety.
Right.
How would you? And a lot of times, the DMCA is used as a mechanism to demand takedowns of copyrighted works. What is your opinion of the DMCA, or how does the law interpret the DMCA, or in your realm, what is it?
I think there is a lot of the DMCA that was an attempt at a good idea in the way we understood how technology would work in the late 1990s. And the problem is, technology does not work the way we thought it would in the late 1990s. And even to give credit to the people that wrote the bill, who I do genuinely believe were trying to do the best they could, it doesn't work in a way that they couldn't have possibly predicted. Because remembering at the time, like when the DMCA was written, I still thought Hamster Dance was pretty neat, right? And so the idea that you and I could be sitting here on a platform that has to monitor whether or not one of us starts playing copyrighted music live to anyway, for us 5 viewers, but plus on my side, plus however many you have. But for like someone like Jacksepticeye or Markiplier or Let's Game It Out, tens of thousands of people, no, they couldn't have seen this coming. They couldn't have seen Facebook coming. We
real quick, I'm sorry to interrupt. As far as I understand, Twitch does not monitor the real-time use of copyrighted work. It's on the VODs.
It only does it on the VOD. It only does it on the VOD.
That's that's kind of a non sequitur.
The idea that there is a whole ecosystem of people putting this kind of thing out there and putting millions of hours of it out there every single day, I think it just breaks the DMCA, because the DMCA could not possibly have understood that. Mm-hmm. And I agree with you that I think that there is a lot of the reverse engineering side, I think, is the problem when you start to bring patent concepts into copyright. Because when you get a patent, you have that patent for whatever you've created, especially if you have a patent on a process, and or even just a patent on the outcome. If someone else figures out how to do it, even if they don't know that you have a patent in it, and starts doing it, they violated your patent.
Yeah.
And so I think that works for patents, because patents are much more limited. They are harder to get. They are open to challenges based on prior art or non-obviousness, and the non-obviousness standard, just because I want, in case my IP professor ever sees this, it is must be non-obvious to a fauceta, a person holding ordinary skill in the art.
Hold on. Ordinary skill in the art. What does that mean?
So, in order for something to be non-obvious and thus patentable, it can't be obvious to a normal person with a normal level of skill in that area.
In that area, okay.
Yeah. So, if you wanted to patent something, bad example because computer programs aren't patents. Um,
Well,
if well,
there
if
are a lot. It's actually
there
terrifying.
are,
Software patents are broken in so
yeah,
many
there.
ways.
But if you wanted to patent something that was an improvement on a previous technology, they examine it from the perspective of, is this an obvious iteration, right? Like you can't get a patent for something that just makes it run 25% faster. Um, unless that improvement is non-obvious. So it's patents are harder to get, they can be challenged, and they have a much shorter amount of time because a patent is 20 years, renewable for another 20. So we grant a lot more protection because they are more difficult to obtain and they last for less time. And in the DMCA, the issue with the backwards compatibility is that we are taking that level of protection against even reverse engineering or accidental engineering and applying it to a much more amorphous field with much longer terms of protection. And that's without even getting into that copyrights last for too long.
That's an interesting argument, isn't it?
I mean, we have certain obligations under the Berne Convention, but I would definitely and I would never be in favor of copyright being less than life of the author plus an amount of time, but I definitely don't think it should be 70 years.
Because if we had actually maintained the original copyright lengths, Star Wars would be outside of copyright now.
Oh, if we'd maintained the original 14 plus 14, Star Wars would have been out of copyright in like 2001.
And in some situations, copyright continues to be extended. Consider Mickey Mouse.
Yes, although Steamboat Willie is public domain.
Is it now?
I think it hit. I will have to 100% check that, but
that might not be true because Disney has deep pockets and Congress is full of corruption.
Okay, it is not yet, but it is going to be in 2 years.
Yeah, guaranteed in a year that'll be fixed.
So far, Disney has indicated they don't want it to be.
Probably because they think they can protect Mickey Mouse himself. Because okay, I'll just consider this. Steamboat Willie is no longer subject to copyright protection. Where's the first place you're going to see a derivative work of Steamboat Willie will probably be Pornhub.
Oh yeah. It's gonna be wild. Well, but you bring up an interesting point that just because Steamboat, I think Disney is not pursuing it for a couple of reasons. One, because we're in a very different place regarding copyright than we were in the 1990s. And two, because like you said, Steamboat Willie is not Mickey Mouse.
It's not the Mickey Mouse we know anymore, is it? It's fairly different.
Just because Steamboat Willie is usable doesn't mean Mickey Mouse is usable. And you see that kind of bifurcation with Sherlock Holmes. Because all but like 7 Sherlock Holmes stories are now in the public domain. So you can use anything from the public domain Sherlock Holmes stories, but you cannot use anything from the ones that are still copyrighted, which means like John Watson gets a second wife. She is still copyrighted. There was a whole fight over the movie Enola Holmes that just came out on Netflix because the estate of Arthur Conan Doyle is desperate to maintain its ability to license out stories. And so they were arguing, and APARC just brought that up. And APARC, do you know if that's been settled? I haven't seen anything on that in a bit. They were arguing like, well, this depiction of Sherlock Holmes is clearly drawing from materials after the public domain date. and so owe us money. And A-Park thinks that they settled.
They might have settled
But, like,
because there's a lot of money to be had overall.
but yeah, so that's a really interesting thing about copyright is that you can end up with weird situations where you can have Steamboat Willie getting his steamboat tugged in Pornhub, but you put those red pants on him, it's going to be an entirely different matter.
Yep.
Which is why
absolutely.
I love copyright, because you someday you're going to have to argue, well, no, that pornographic film featuring a cartoon mouse was clearly Steamboat Willie, not Mickey Mouse.
So where is the line drawn
there is.
between trademark and copyright?
Trademark is over brands and logos, and copyright is over creative works.
So what's the difference between Mickey Mouse and Steamboat Willie?
A-Park points out, I think it's funny you guys don't think there's already animated Mickey Mouse porn.
Oh, I know there is.
But,
obviously there is. It's whether or not it's legal.
And he also answered your question. It's usage. Mickey Mouse can be both a trademark and a copyright.
You're right. Absolutely. So where does copyright end and trademark begin? Is there a line? Does there need to be a line?
And I think the line would be, you can have Steamboat Willie appear in your black and white pornography. You cannot have Steamboat Willie branded lube.
So what's the difference between, like, say, a particular cartoon of Mickey Mouse, which would obviously be copyright, and an image of Mickey Mouse, which would be more trademark? Where's the difference? Are you able to make derivative works from the Mickey Mouse cartoon, even though there's a trademark on Mickey Mouse?
Yes. What you can't do is use these protected branding, because, like, it is not the image of Mickey Mouse that is protected. It is the name Mickey Mouse in a certain font, in a certain color, in certain streams of commerce. Now,
but even images of a character can be copyrighted. It can be trademarked.
Yes. Well, but only that specific presentation. So, like, I have my Owl and Gavel logo for the channel. That could be, if I slap Ad Hoc Games on it, and I could trademark that in certain streams of commerce. But if that was in the public domain, which it might be, because I don't actually know where the designer got the art assets from, somebody else could use that. They just can't use it in branding or trade, but they could put it in their cartoon, because it's not. Trademarks are protected in specific iterations.
Okay. Interesting.
And that iteration is both the presentation and the stream of commerce that it's in. Like, McDonald's owns the name McDonald's in a variety of food-based commercial areas, but, like, it can't stop someone from starting a law firm called McDonald's.
Okay. Huh. Okay. Interesting.
And that's so when you apply for a trademark, you have to specifically apply for certain streams of commerce as defined by the USPTO. And you are only protected in those areas that you apply for and you receive and you use.
Okay. Interesting.
So, like, Steamboat Willie could probably appear in your films, but after the public domain date moves forward that far. But you're going to have more of it. You can't put the Steamboat Willie as he is used in Disney marketing on a T-shirt.
So that's an interesting statement. As he is used in Disney marketing. So, but that could mean like you're not necessarily talking about a particular freeze frame of Steamboat Willie. You're potentially talking about the idea of a mouse, and let's just be kind of specific, a mouse holding a wheel. Could be a trademark image.
Yeah, and that's. But what's important is that it is what is specifically registered that is protected. And the standard, as A Park points out, is likelihood of confusion. If you can show that there's no likelihood of confusion, then you are well on your way to winning. My favorite is in the UK. One of the
I guess that's actually where I'm going toward. You mentioned likelihood of winning, but you still have to fight.
Oh yeah, everything you still have to fight. There are very few ways to say definitively this cannot result in a lawsuit.
So, how would you, as an independent, small-time, penny poor porno shop? Let's be specific.
I mean, really make sure this can't be monetized.
Yeah, pretty much. I mean, we're just talking. It's words. Monetized. You can be monetized. I can't. I'm a little person.
On YouTube, I can't be monetized. You need 1,000 subscribers.
Exactly. Yeah, I have like 3. But like, how would anyone in that kind of situation hope to be able to withstand a lawsuit coming from Disney?
And that's one of the problems. You're getting into the problem of access to justice. They couldn't. They would have to go on Twitter and tweet, "Please help! If anyone knows a lawyer, I'm being sued by Disney for my Steamboat Willie brand lubricant," and hope that they'd get taken up with an attorney who would do it for free. And that happens. Mikey, A Park, and I all follow a Twitter account called Pope Hat that will absolutely put out Twitter like First Amendment. Hey, this company is doing something shitty. They need an attorney licensed in this state. They're being copyright bullies. Do you know someone who can help them, or can you help them? And it will get responses, but the access to, yeah, we both know a guy who would 100% do that on Twitter.
I know a guy.
But that is an issue. It is an inherent imbalance in the system that there is a lot of stuff out there that is fair use, and that the person would prevail on fair use. But Disney sends a C&D and they're like, I don't have $100,000 to fight Disney on this C&D, so I'm just gonna stop.
That you'll never get back.
Yeah, it's and that's true across the board, right? We need to address access to justice across the board. And I think one of the ways that we do that in civil law is we pass more anti-SLAPP statutes. And a SLAPP refers to a strategic lawsuit against public participation, which is where a company or a powerful individual sues you to shut you up because it knows that you can't afford to fight, because they say are a disgraced voice actor with a $250,000 war chest, and you don't have that kind of money.
Are you talking about Matt Mercer? My goodness. You're going to call him disgraced?
No, no, no,
Sheesh.
no, 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 no. We're talking about. Let me not get the Critical Role fans in here yelling at me. Instead, let me get the same people that have already doxed me mad at me. This specific one is called Vic Mignogna. And so you just hope that you live in a state that's passed an anti-slap law, and like Texas has a strong anti-slap law that says basically if you can show at a hearing much earlier in the case than you would normally get to have this hearing that this is meritless and it is only designed to stop you from commenting, you can get it dismissed and get attorney's fees.
That's not bad.
And that's the big part that makes it, that gives it teeth, is when you've got a anti-slap law that awards attorney's fees, because you then you are really disincentivizing it. A-Park points out this wouldn't apply to most copyright lawsuits. No, anti-slap wouldn't, but
there are variants of that kind of thing that exist in some other jurisdictions. I've heard of something similar to that in England. But I get what you're saying. You're talking about more in general of some
this is
kind
more
of
of a
reform.
general thing rather than copyright. We need to address the fact that it is very expensive to go to court, even to defend yourself with a very meritorious claim, and even to win.
So I'm going to see if I can kind of steer us back a little bit more toward the central theme of our conversation. But I will ask one further question on that particular line we're going down.
Sure.
How good of an idea is it for a normal person to go in front of a judge and argue his case?
I mean, the old adage that anyone who represents themselves has a fool for a client pretty well applies. In even attorneys, like when Rudy Giuliani, I'm going to defend myself. Like, no, I mean, don't get me wrong, it'll be funny. I want you to do this, but as a lawyer, I don't want you to do this because it's very stupid.
Rudy Giuliani, Sidney Powell, etc., etc.
Right. It's a bad idea, even if you are a hot shit attorney. And importantly, no one is as hot shit an attorney as they think they are.
I mean, just in general, when you're in the middle of a situation that's high stakes, you're never going to think clearly. It doesn't matter how good you are not going to think clearly because your ass is on the line.
Yeah. And part of what a good attorney does for you is give you a more objective outside look where they say like, yeah, this is going to go real bad, dog. You need to not be doing this.
Yeah. So let's get us back right into the core of our conversation. I love these tangents, by the way. I'm not trying to stop the tangents. I'm just also very well aware we have a core theme. We're going off on tangents. And there is a point where this is kind of involved. Oh, well, we just went past it.
Yep, no, we're definitely not. Yep.
So, the conversation about what it means, like allowing equal access to justice is a very important topic, particularly in the United States. Only because it's where we live, but it's also an important topic anywhere. But we're going to try to limit scope. It's a technical term. It's a computer science term. We limit scope. We're into the scope creep.
Okay.
These are terms that I hear a lot in my line of work.
Okay.
So I'll ask you the question. What are some of the unintended consequences of the Oracle v. Google decision?
I think 10 years of litigation are the unintended consequences, I think. But also, that is an interesting question because I think part of it is, I don't think Breyer doesn't intend a lot of what's going to come. Because again, I think Breyer wanted to light the bridge on fire behind him. He wanted to talk about copyrightability. And yeah, I think the next 10 years are going to be every possible industry tries to limit the Google v. Oracle decision to not them. And it kicked off a lot more litigation. I think it needed to. I think we needed something to really define down how copyright and how fair use apply to these areas. And I think Breyer intended to do it. Unintended consequences could absolutely be Congress decides to try to be more specific in its statutes and really takes Google v. Oracle as the guiding principle in how it writes the next Digital Millennium Copyright Act.
Do you think there's impetus to do that right now? I don't think there is.
There is widespread impetus to at least address part of the DMCA.
I mean Google v. Oracle specifically.
I don't know. Like I think you're right that right now, no, but we're also only 24 days past the decision. I think it is going to take the next 2 or 3 cases for people to really know how far the Supreme Court is planning on going with this direction. And that will be what decides what kind of the next several years of or even decades of unintended consequences are. Is how sweeping a change is this? How many fields does this apply to? Is it, as APARC and I are proposing, a very radical and widespread change in how one views fair use? Or is it, by its nature, limited to a software law or software programming where that kind of copying is much more necessary? So I think a lot of that was intended, but I think some of the answers are going to be not what Breyer intended. And especially if Breyer, as many are hoping he will, retires in over the summer because he is 90 years old and has a stent in his heart.
Oh, wow.
Yeah.
I didn't know he was that old. Holy crap.
Breyer's not
He's pretty damn good.
Spring chicken.
So, I have a question from Homeless Rhino, and I was going to ask.
I'm sorry. He's 82, not 90.
Oh, 82. Okay, that's still fairly old, but wow. I said I was going to ask one question, but there's a different question that I'll ask instead. Okay. It's the one that he just asked. There's a sizable group of people threatening Section 230. Am I archaic for thinking they nailed the DMCA the first time?
So, no, I don't think you're archaic, and I don't disagree. Without Section 230, we would not have the social media the way we have it. It just would not exist.
Let's go with the DMCA first. Let's talk about that a little bit, and then we'll get into Section 230 because that's a really good conversation to have. So, do you think they nailed the DMCA the first time, considering the time period that they wrote it, considering how things have gone since the DMCA? And I'll go first, just with my own point of view, because I was definitely around when the DMCA was first written, and I was in college for computer science, and I felt in a lot of ways this was an attack on me as a person, in my profession, that this was a law that criminalized curiosity. So, your opinion, what do you think they nailed the DMCA the first time?
So, and we talked a little bit about that earlier. I don't think they nailed the DMCA. I think that they genuinely tried, and that there are a lot of principles in the DMCA that aren't bad. But that, like I said, our technology moved in ways that we could not have expected in 1998.
Mm-hmm.
Our technology ecosystem and economy and understanding and the importance of it in our day-to-day lives was not something that we predicted in 1998, and certainly not that a bunch of 60-year-olds in 1998 predicted, right? Because, Congress is old.
And now they're 80-year-olds, the same
and
people.
still in Congress. Yeah. And I think you see that in things like takedown notices, right?
Yeah.
Those made more sense when we viewed technology as fundamentally being like news media, right? There's going to be, anyone can print their own pamphlet. Yes, APARC, I got a little confused. APARC is pointing out Section 230 is not part of the DMCA.
It is not.
I was conflating them because both.
You were conflating them because the original question from Homeless Rhino put them together, and that's why. And I separated them.
Yeah, as part of this, it's part of the Communications Decency Act. I think that the takedown.
No worries, Homeless Rhino. No worries. Perfectly okay. Perfectly okay. But the 230 is an important topic, and we will definitely be getting to that soon.
So I think that it reflected what they thought was going to happen. That there would be, lots of people can start their own website, but there's going to be like 5 big websites that everyone goes to. So they just need to worry about takedown notices. And that's the big, and like small websites shouldn't use other people's stuff, but they'll probably only get a couple DMCAs ever, or a couple takedown notices ever. So it'll be fine. And then Facebook, and then Twitter and YouTube and Twitch, and it's like, oh no, now we have, between everything, hundreds of millions of words and hundreds of millions of hours, and companies that being put out there every day, and companies cannot possibly keep up with all of them. So they just set up algorithms, and they just set up auto takedowns, and there is no oversight in a system that would work if there were 5 websites everyone went to that could afford to have people who actually looked at things and judged them based on the merits, but absolutely does not work when we see people like Addison Kane weaponizing DMCA takedowns to take out people she doesn't like or critics.
We'll get to that we'll get to make sure to make a note of that.
Addison Kane, okay.
Yeah.
There's an hour-long video I can link to.
Absolutely. But on that exact point, there's a comment from Janissary on mine. A lot of the initial enforcement of DMCA takedowns is automated by algorithms. What's interesting to me is that is a very new thing. Like you said, DMCA is from 98. Automated takedown systems didn't exist until maybe 2010. So these algorithms that have come out are really new. The idea of using the DMCA to deal with, in whatever way, copyrighted content being used illegally. I will say illegally because, frankly, it is against the law. You may think that it shouldn't be, but unfortunately, or fortunately, depending on your point of view, it is. Using copyrighted content without permission is illegal. Absolutely it is.
Unless it's fair use.
Unless it's fair use, and then that starts getting into wibbly wibbly timey wimey situations in law. She asks, do you see that being used in lawsuits in the future to determine how alike certain works of art are? Has it already? And on the technological side, I would actually say that the use of algorithms for copyright issues, I will say it in that way, has already especially like with Hornless Rhino saying with the AI with the AI systems that are coming out, I would actually say that these systems are avoiding lawsuits because with the DMCA in existence, you now no longer have these large corporations submitting to YouTube cease and desist letters. You have these large corporations submitting to YouTube, hey, this person is using my copyrighted content. And now there are different levels of enforcement of this situation. Most copyright owners do not demand takedowns or demand copyright strikes. Well, I should say actually demand takedowns of user content. It's a very interesting thing. Most copyright, so I'll say it again, most copyright owners do not demand takedowns of user content. So, to demand a takedown is usually what some people would call a copyright strike. So most systems, they have a 3 strike systems. 3 strikes, you're out. If you take people's copyrights worked and the copyright owner demands a takedown, 3 of those takedown notices, you're out. There are, in some of these platforms, various ways of defending yourself against these strikes, and in various ways they are either successful or completely ludicrous. But for the most part, that's not what happens. What happens is one of 2 situations. Either they demand, in the case of Twitch, they demand that section of a stream, of a VOD, that section of a VOD be muted. Or in the case of YouTube, that any monetization for that section, for that portion of a video, I'm not 100% sure if it's portion or entirety. But for that video, either a portion or the entirety of the monetization for that video be redirected to the copyright owner. And that is not a copyright strike under YouTube. That is only a demonetization. That money is no longer going... Huh? It happens all the time. It happens all the time.
Something I streamed on this channel.
Yeah. Happens all the time.
I think that is...
Did you actually get a copyright strike? I'm gonna be curious.
No, I got a demonetization. Oh, well, I got a remonetization because my stuff isn't monetized. But Atlas, who own the Persona series, automatically, I think, just have their stuff scanning. And I'm playing Persona 4, and I posted it, and they're like, "Hey, that's our music.
Yeah,
that's our stuff." And so now I think there are ads on it that go to Atlas. That's like, okay, I could have made I could have fought it on fair use, but I also don't care.
There has been no case law on the use of most Twitch, especially YouTube, somewhat less. No one wants to get into the question of is the use of video games or the assets of video games allowed to be used in other ways in terms of copyright. No one wants to answer that question.
I want to answer that question. I want to make them answer that question.
Well, I understand you do, but unfortunately, Nintendo did. Oh, good question. Did Nintendo try that?
So there are some companies that are very heavy-handed about
That's a specific question from Janissary and Homeless Rhino. Did Nintendo try that?
A-Park says kind of, and I agree kind of, in that Nintendo is really aggressive about it, and I think has gotten closest. There has not been, like you said, I don't think, unless A-Park wants to correct me, I don't think there's been any even lower court specific ruling on whether or not that's protected. And especially like whether what we do on Twitch would count as commentary under fair use. But A-Park is pointing out they did a whole thing trying to force creators into a special program with more oversight or risk strikes, but I don't think there were any court cases. So
yeah, that's the thing. That's then, and when I mean like what I kind of meant was I don't think anybody truly wants to get the courts involved. No one wants to get the courts involved. And I would even bet that even if Nintendo wanted to get the courts involved, I think a lot of their publishers and a lot of other people in their circles, in their communities, and I mean like EA, Blizzard, etc., 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 I think that they probably told them, don't take this to court, because they don't want to have that decision made.
Oh, yeah.
Because either way, someone will lose. Right now, a lot of game developers, a lot of publishers, a lot of studios, a lot of people like streams because it gives their games exposure and lets people play games that they wouldn't normally see, or it lets people be interested in games that they wouldn't normally see, and maybe even buy those games that they wouldn't normally buy. Because, hey, this person that I watch, I love their game. But the opposite argument made by some game studios, developers, etc., they might say, I will never buy this game because because I've seen how the game goes, and now I don't need to buy it.
I have experienced the game in its entirety. Why do I need to buy it?
Exactly. And for me, I can actually say that in both ways. On the one hand, I've seen a lot of games that people have played and like, oh my god, I love this game. I love everything about it. But also, like, I've watched Jacksepticeye play Little Nightmares 2 and talk about Little Nightmares 1. And now I don't have much desire to want to play that game because I already know what's going to happen.
Right.
Because part of my stream is I want to experience the story. Not every streamer is going to be in on that. And honestly, for anybody who's watching, play Little Nightmares 2. It's an absolutely amazing game. It's a beautiful, gorgeous, oh my god, amazingly bizarre game. Play it, please. But I probably won't because I know how the story goes. And so it's not an opportunity for me to experience this. And it's kind of sad, really, because having seen that game, I would love to play it. And I might just buy the game just because I want to support the studio, because they've made something that's absolutely beautiful. So, what do you think is going to be the future of the DMCA with respect to streaming platforms?
I think and as it becomes more and more a part of the internet economy, something has to give. The current system is untenable, and there is an increasing amount of people that are annoyed at how the DMCA has created opacity in the system, because as we've moved to millions and millions of hours being made every day, it's impossible for people to review by hand. Therefore, the default, it has gone much more to the default of, you complained, we believe you. And it can be very difficult to fight that, and it can be weaponized. And so I think that we are going to have to see something that recognizes the fact that companies like YouTube can't manually review, can't have a human set of eyes looking at everything. But I think also we're going to see a push for requirements that make it a little bit easier for the affected to push back and have a chance to respond before automatically losing that video or losing their monetization.
Well, your mention of YouTube is very interesting on that point, because while in like, for what you just said is like 98% true, but they do have some bandwidth for manually reviewing the counter complaint. So if a copyright owner says, this is my video and I want to take the monetization for it, there is an ability for YouTube to manually review the counter complaint of, no, I did not actually use this video. And there was very recently a court case where either YouTube, Google, or Alphabet, I forget exactly which entity because they are different, sued one of their complainants for taking advantage of their system, and actually defended their users against a copyright abuser.
I think part of that, APARC, wasn't part of that what Lindsay Ellis was talking about. Because when I mentioned Addison Kane earlier, what that is getting into is that there is a person who writes Werewolf Erotica.
It might actually be related to that.
Yeah.
Go ahead and talk about Addison Kane, because you were going to talk about that.
Werewolf Erotica and has been weaponized. APARC has been weaponizing the DMCA. And she did it in against Amazon for another author writing in the same sphere, and then YouTube, not even sure how to describe her, YouTuber Lindsay Ellis responded to this whole thing, and then her videos got DMCA'd. And YouTube actually was like, nah, this is bullshit. We got you, fam. I was like, oh my God, I didn't know YouTube actually did that. But
I think YouTube does not like DMCA takedown notices, like copyright strikes. And I think they actually do retaliate against individuals who overused copyright strikes. I may be wrong about that, but I think, like, because there's a very big difference in YouTube's mind between a demonetization event, which is relatively minor, mostly automatic, because their own content ID system will identify, hey, this has already been identified as a copyright work, you're using it, we're going to notify the copyright owner, and if they say, yeah, this is copyright, we're going to demonetize your video. A takedown notice is very different in YouTube's mind.
Well, and I think that it also, like, Lindsay Ellis is very well known, has 1.14 million subscribers and like 114 million views, and is now a New York Times bestselling author. So I think that they're also better about doing it when someone with an actual recognizable brand is involved.
It's true.
but I think, yeah, it's that demonstrates kind of some of the flaws with the system. And yeah, YouTube is better about it in the counterclaim. I think to answer the question of where I think we're going with the DMCA overall, I think it is toward a system where there is automation, there is an algorithm, but there is some input before the monetization is taken away, right? Before, like, because right now it says the DMCA says you have to act on it in order to maintain your safe harbor. I think we're going to see specifically a movement towards you have to investigate, or you have to ask for a response, and you have to resolve it within a certain amount of time.
Right.
But I think we are going to see a movement away from the system where it's they said it, so we're either taking your money or we're giving you the strike, and then you can possibly get a human involved if you counter complain. Yeah, Mikey says part of the problem with how YouTube handles the DMCA claims is that they're doing the bare minimum to keep themselves out of legal trouble. And I agree.
Right.
I think we're going to see that floor raised a little bit, because all of a sudden this is a lot of people's jobs and this is a huge amount of money in the economy. It's
so I will vaguely tease Section 230, because we're going to get into that particular conversation, because even though that is Communications Decency Act, it definitely does apply to copyright. I'm going to rewind a little bit on my chat stream. I have Homeless Rhino who said that he thinks that he seems to recall that Nintendo might have stopped a gaming tournament over copyright. I have not heard that. So if anyone on your stream has heard...
I think I have heard something similar, and that gets into a really interesting part of copyright law, because it's getting into public performance.
Yeah.
Because public performance is a right that they have a right to restrict, the same way
a right to control.
You have to get permission in order to play songs, specific songs in public. There are licensing involved there, and most don't choose to, because they view gaming tournaments in public as being kind of free advertising.
Especially for something like League of Legends.
Right. Yeah, if your game gets picked up at EVO, you're going to have eyes on it. You're going to have people dedicating themselves to getting better at it to go win tournaments, and that's money in your pockets. So it's that's an area where they can, but they don't always choose to.
Yeah. Another comment from Homeless Rhino. I came across a really cool Python thingy. Python is another programming language called Spleeter. It uses TensorFlow. I don't really know what that is. I think it's something to do with some of the AI systems that are in some graphics cards, or various other systems in graphics cards, and can disassemble a song to the drums, keys, vocals, etc. I imagine the algorithm will improve and takedowns will happen often and force creators to plead their fair use case. Basically, I think what he's talking about is algorithmically generated music.
Well, and algorithmically dissected music to compare similarity. Like, because he had specifically asked about using algorithms in order to determine how alike things are, and whether that will have a place in copyright. And the answer is copyright disputes. And the answer is yeah, and it already does. It is already here. That kind of thing is in use. Especially, like, think about plagiarism software, where it can tell you how much overlap there is between your work and another work, and you can get in trouble in a college class. And it's like, yeah, that kind of stuff, I absolutely guarantee you, is being used in
Yeah.
in lawsuits because it makes it easier to tell. It is a weapon, or not a weapon, it is a tool to be used for either side.
Absolutely. And that actually goes to another statement from Homeless Rhino about using AI with respect to DMCA takedowns. And this will kind of skirt the edge of being on topic, so I'm not going to talk about it too much. But artificial intelligence for the use of these kinds of things is definitely growing. So a lot of times you'll hear about you'll hear a lot of YouTubes talk about the algorithm. This horrifying term, the algorithm. And it's an AI system. So a lot of people who are not technical at all or are not YouTube content creators at all think about AI in much the same way as they think about the Terminator. This machine, like, or Skynet kind of thing. This machine that thinks just like a human. And actually, like, I play Cyberpunk, and they talk about AI, but they also talk about AI as being very alien. AI does not think like a human. And modern AI definitely does not think like a human at all. Modern AI is very much, you can almost think of it as a massive decision tree. You have a condition, a picture, a sound bite, a video clip, etc., goes into this decision tree, and as it travels the decision tree, all these little knobs and buttons have been set initially, and it keeps going into this extremely complicated pre-configured decision tree, and it ends up with an answer of, yeah, this is a copyright infringement of this video over here, or nope, never heard of this before. And there's a couple ways that these kinds of algorithms can be manipulated. One of these ways is by twisting these knobs all over the place, just little tiny ways all over the place in this billion tree dependency tree, decision tree. And by basically, with the more data you have, and what better way of getting data than with YouTube, with millions of hours of video uploaded a day? Entire lifetimes of universes can be uploaded in a single hour, in a single day on YouTube. You know? It's incredible.
Every day.
It's incredible. So YouTube, all AI systems rely on data. They need to receive data, and they need to process data and come up with results, and have other systems, sometimes humans, most of the time machines, that analyze the answers and determine, was this the correct answer? And if it's not the correct answer, either the human or the machine goes in and starts twisting random knobs and seeing if they can come up with a better answer. And if they can't, well, let's try it again. I'll see if I can find and post a link. I'll do a quick search of a CGP Grey video talking about how artificial intelligence systems are defined. But artificial intelligence does not think like human beings. They are very other in terms of how they think. And these are, the way that current computer science is kind of going with in terms of artificial intelligence, it's very much a system of artificial intelligence tends towards specificity, whereas the human mind, actual intelligence, tends towards generality. So a human mind can very easily, like, with just a few changes in where I was interested in my childhood, I could have easily been a lawyer instead of a computer scientist. Just before we had this conversation, we were discussing the jurisprudence of an organization we're both a part of, and
Yeah.
I've done a lot of research into that, and I don't know why. I'm not a lawyer. This doesn't interest me in the least, but I thought that was cool. And I had a very deep conversation about a matter that I don't have a lot of experience in. And I know with the way that I think, I could have easily become a lawyer if I was interested in that. Whereas in the terms of artificial intelligence, you really only have a situation where you create an artificial intelligence and it becomes really, really good at playing Go. And it's really good at playing Go. It is so good, in fact, that professional commentators on games of Go are like commentating on the actions of the computer in terms of a human being rather than as a computer. And like recognizing, oh, this is where the computer had made a mistake and now he's trying to recover from his mistake. So it's super interesting. I'm sure you've heard about it, of I believe the computer is called AlphaGo, the system that Google had created that went up against a Go master, and it was a best of 3 tournament, and the computer actually lost the first the first 3 tournaments, but they played all 5, and AlphaGo won one of the 5 tournaments.
Interesting.
And it was a challenging game for the person because there were different strategies that the computer was trying. It's one of those really interesting things of artificial intelligence tends, at least the way that it's going in terms of modern computer science, it's tending towards specificity rather than towards generality. Even what looks like a very general system, like my Google Assistant over here, who I am now going to mute, just in case someone decides to yell really, really loudly. My Google Assistant, it seems like, oh, it's very general. I can ask it any question and it'll get me the answer that I need. Well, actually, no. It's a very specific thing. It's a voice processing system that's connected to a very good search engine.
Yeah.
And voice recognition is very complicated, and they've got it. Searching is very complicated, and they've got it. But these are very specific systems. By putting them together, it seems that they're very general, but they're not.
Mikey said that the name of the CGP Grey video was Humans Need Not Apply.
It's not that one. That's a different one. I will look up that, but thank you for reminding me. Otherwise, I was forgetting what I was going to look for. But yes, you're absolutely right. Humans Need Not Apply is a very important one. That's more about jobs that humans will be in. It's a very important video to watch, but the one that I'm talking about is a little bit different, and I will look it up right now.
Section 230, I think, is the one where I think generally Section 230 works pretty well. I think the attacks on Section 230 are currently politically motivated rather than functionally motivated. They are people trying to it is called How Machines Learn. Mikey, can you
I got a better I sent you a better link.
Let me grab that. I'm going to send it to Mikey and ask him to throw it up in the chat. Since my computer, I closed everything that's not this to save bandwidth, and my phone is about to die. So I'll have him throw that up. I think Section 230 generally works, and I think without something written broadly like Section 230, we wouldn't have social media like we have it. And now you can say whether that's a good thing or a bad thing for our country and humanity, fine. But thank you, Mikey, for throwing that up. But that kind of instant connectivity and the ability to share all of the things that we share on social media does not exist without Section 230. YouTube doesn't exist without Section 230. Twitch doesn't exist without Section 230. Because otherwise...
What is Section 230?
Section 230 is specifically the section of the Communications Decency Act which says that a social media... Well, a platform is not a publisher, in that a website or a social media site is not responsible for the things that are posted on it, in the same way like a newspaper is responsible for the things that are posted on it, because it's exercising editorial discretion. YouTube, Twitch, Twitter, all of those don't exercise editorial discretion. They exercise their terms of service. And as long as they are not essentially moderating viewpoints, they are a platform, not a publisher, and thus they cannot be held legally responsible for anything that someone says on it. And that's important because it means we can have this conversation about various forms of copyright protected Mickey Mouse erotica. And someone couldn't sue Twitch for us being indecent if they thought we were being indecent, right? Or, you know, people that get into fights based on things on social media, or even copyright infringement. As long as you are not exercising editorial control like that, you are a safe as being a platform, not a publisher. Right. And the accusation is like, oh, well, you censored, at real Donald Trump. And it's like, well, because he was violating the terms of service, because he was spreading misinformation. Like it is, the line can be a little bit tricky when, say, you have a major political party dedicated primarily to spreading misinformation, but it is not generally held to be viewpoint moderation to say you can't spread obvious lies or incite violence.
Right.
Section 230 broadly works, right? Like,
yes.
Josh Hawley yells about how big tech is silencing him, but he's doing the yelling on his Twitter account and selling the book that he's selling through Amazon.
Yep. And consider that we're on a Amazon-owned system. I'm going to be uploading this on a Google-owned system very shortly. It's one of those things that, I mean, the fact of the matter is the people who say we need to repeal Section 230 are also the people that say companies should be able to control their assets. And Twitter, Facebook, Google, their social media are their assets. Are you going to say that you can't do what you want with your own assets that you built?
Well, and that's,
how interesting.
Yeah, and I just got a text from my brother saying you're getting a decent amount of this wrong, so I'm going to let him correct me.
Oh, okay. Yes, let's find out what we're getting wrong. Let's please understand this.
As he composes that, the distinction is not the difference between platform and publisher. He is writing more. But I do agree with you on the general. These are all private companies doing running their private enterprise. And
right.
If you get banned from Twitter, you have not been banned from speaking truth to power. You have not been banned from getting your truth out. You have been banned from doing it on the house that Jack built, and that's yeah.
And I do have to I do feel compelled to say that with the way that Twitter and Facebook have so suffused public discourse that questions are now raisable whether or not what we're actually doing is a good thing, TM, of, do they have too much power? Are they stifling free speech? And these are decent questions to be asked, but these are questions that can only be asked now because of what they have become, because we as consumers of these platforms have allowed them to become. So I think using the protections of Section 230 as a cudgel against these companies is fundamentally wrong. We now have to ask a more serious question. Perhaps it's good, perhaps it's bad, but it's a serious question. Should these platforms be nationalized? Should they be considered to be platforms of free speech and therefore subject to government regulation?
So APARC is correcting. The statute provides for protection for all websites against liability for any content created by a third party. They do not need to behave as a platform to get it. 230.
Yes, you are. That is a good clarification. Yes.
230C2 is the part that allows them to remove content and explicitly allows them to engage in viewpoint discrimination, since no one wanted Granny's Christian Forum to not be able to remove content about abortion rights.
Right.
And that is correct. I was actually using the language that they use that are the right-wing talking points because I was doing this off the dome and being incorrect about it. So as I told him, please don't be afraid to correct me on stream because nobody else is.
I'm certainly not correct on most of these.
I don't know. I think that it is certainly worth talking about the role that we have allowed social media to play in dominating our discourse. Yeah. But it is not. There is not a traditional understanding of the ways in which something becomes a public forum or a agent of the government that would currently apply to Facebook or Twitter or any of them. And so we would really be in uncharted territory if we were saying that we needed to seize the means of production in order to protect the national discourse. And I don't know if that would be good or bad, but it would certainly be a very different way of viewing it than we have traditionally done so.
I'm sorry, it's probably just I may have misheard. It may just because they are very similar. They have very similar sounds, and I may have misseen. Did you call them the means of production or the memes of production?
You actually said it. Memes of production, yes.
I love it.
That is
the memes of production.
Another paper that APARC and I want to write is titled "The Memes of Production."
Nice. I approve of this, sir.
Specifically about whether or not memes are copyright infringement or transformative use.
Ooh, that's an interesting question. That is a very interesting question.
We don't know the answer that we're coming down on yet, which is why we have not written the paper.
Ooh, can you argue both?
I think you can argue both that they are.
Ooh, now here's a meme. Choose your own adventure. Choose your own ending. Have the user decide. Okay.
Oh, interesting. I love it. There is a guy on law Twitter named Brian Fry that would absolutely lose his mind over the ability to write a choose your own ending law journal article. I'm not sure it'll fly in most of academia, but I think we need to tweet that at him now. Because he is a guy. He is a guy who hired a plagiarist to write a paper for him about plagiarism in college and law school, and fully admitted, I paid someone to write this for me.
Oh, that is so fucking meta.
He is like a Dadaist in legal academia.
That's amazing.
Yeah,
I love it so
he's
much.
he's a real interesting dude.
Wow.
He once put out, hey, because I think, I don't know even why he did it, but he was like, hey, I will transfer one of my law journal articles, the credit for one of my law journal articles to anyone who says it. Just tweet at me and tell me what you want. And so technically our dad is credited as a law journal author, despite not ever having written or being a lawyer, because Andrew thought it would be funny.
Nice. Hey,
Yeah, he's is he at Brian L. Fry A Park?
I think that'd be, considering the meta-ness of this whole thing, I think that's actually awesome.
Maybe we can pitch him. Maybe we can co-write an article with him on it.
I think it's completely legitimate. Like, hey, at some point there's a decision that needs to be made. Like, because like you're saying you don't know which ending you want to write. It seems that there's a turning point. There's a decision point in there. Choose your own adventure. Should it go this way or should it go that way, depending on your decision here? And the best thing about it, too, is nothing says you can't go back and try the other thing.
Yeah, now I kind of want to think about this. I just sent you the link to his Twitter. He is a real interesting guy.
Sweet. Are there any other questions for us regarding?
If you believe the transformative use requires commentary on the original, go to page 3. God.
Yes.
All right. So does anybody else in either of the chats have any other questions for us before we start wrapping this up?
It's been a good conversation.
It has. I have really enjoyed this. This was a lot of fun.
We got to talk about a lot of different things.
Yeah, and a lot of really interesting things that I don't think any of us thought we were going to get talking about, but that's, I think, part of the fun.
I think that was really the goal. It'd be super awesome if we were able to come up with conversations that we could talk about again. Because you're obviously a lawyer. I have, you know me fairly well. We have different viewpoints on a lot of things, and maybe it'd be good to just have this kind of conversation on other topics.
Yeah, I am definitely open to doing just chatting, not just on the intersection of law and programming, but yeah, I'd be down to do this again just because it was fun.
I mean, one of the things I was thinking of talking about would be the topic of copyright law with respect to software licenses.
I mean, and we can definitely, I think let's keep a running list and we'll do this again and we'll just hit more stuff.
That'd be cool. Well, thank you all for watching. We really appreciate it. It's been a fantastic conversation.
This has been a blast. Thank you all for sticking around on both chats. Thank you, Omaha Programmer, for the opportunity. We will definitely do this again.
Thank you, everybody, for watching, and I hope all of you have a fantastic evening.